I'd like to take a few minutes to explain how a power of attorney operates and effectively why people will have one prepared for them by an attorney. The purpose of a power of attorney document is to allow someone other than yourself to handle your financial affairs or other related affairs in the event you're not able to do so or you choose not to do it for yourself. And the power of attorney's real use in an estate plan today is to cover situations where an asset is owned entirely by you, not by a trust, not by any other arrangement, but solely in your name. For example, an individual retirement account, by its own nature, the word individual means it's your retirement account, is under your control while you're capable, but if you're not capable or you choose not to have that control, then a person who is named in a power of attorney document would have control over that particular asset. The same rules would apply to an insurance policy that you might have on your life. If you were unable to take care of matters involving that insurance policy and you had a power of attorney document prepared which gave someone else the authority, they would be in a position to take care of those things for you. There are some terms that are confusing to people when they read about a power of attorney. The first one is the title that is given to a person who acts under a power of attorney. The legal term is attorney in fact. And it sounds a lot like attorney at law, but it is a different term. An attorney, in fact, is someone who has been granted power under a power of attorney document to handle things for the person who signed the power of attorney document. They're known as an attorney in fact. In normal parlance today, we find people often saying, well, John Smith will be my power of attorney. What they really mean is John Smith will be my attorney in fact. A power of attorney can either be immediate or delayed. It can have a clause that says it takes effect immediately upon signing, or it can have a clause that says it does not take effect until a physician will state in writing that you're not able to manage your affairs, or you sign a written statement saying you want the person named to take over right away. And when it's a delayed power, it is often referred to as a springing power of attorney. There's another term that people hear, and it is confusing when you first hear it, and that is a durable power of attorney. The word durable means that once you sign the document, it stays in effect until you decide to revoke it or until you die, no matter how sick you might be. So the word durable has to be looked at in that particular context of meaning the document will not lose its legitimacy just because you become so sick that you can't take care of yourself. In fact, that's probably the time you'd want to have that in place. Also, a power of attorney can be either general or limited. General means it covers a broad area of items that can be handled by the person named as attorney in fact. Limited means it's limited in scope. For example, if someone was going out of town and could not attend a closing, they could give someone a limited power of attorney saying that that person had the authority to attend the closing of the transaction, to sign documents for the person who was out of town, and then after that closing was done, the power was gone. So that's why they call it a limited power of attorney. It limits what the person can do. Now, the way powers of attorney have given authority over the years has been quite interesting. Many years ago, when I first started practice, we would see powers of attorney that would be many pages long. I can remember seeing a couple powers of attorney that were in excess of 30 pages. Because in order for the document to be legitimate, it had to lay out all the details of what a person could do with regard to various categories such as real estate, banking, business, insurance, etc. And about 20 or 25 years ago, many of the states got together and said, we need to fix this problem as they saw it by taking all the powers that one person could give to another, putting them in the state statute for that state, and allowing a person in a power of attorney to simply reference the statute that contained the detailed language explaining what the person could do. Indiana adopted that process more than 20 years ago, and so when a power of attorney is prepared by my office, we make sure that we give the title of what section of the law we are referring to, and also a code reference, as we call it, that shows how the authority can be located. And with the development of a good internet system and especially some good search engines, when you type in simple characters such as IC for Indiana code, 30 for the volume, and then a series of numbers, a person can go to their own computer, type in exactly what is shown, like IC 30-5-5-2, and it will take that individual directly to the section of the Indiana statute that explains a particular power of attorney authority, such as, for example, business, personal property, real estate, etc. So this system has allowed us to have a more condensed document that does give all the authority you would have with a fully expanded or typed out document without all the verbiage being involved. The other thing to know about a power of attorney is that it can have some additional extras that you won't find in other states. For example, Indiana has a section of its statute that says a person can make decisions even after death regarding organ donations for the person they represent. It allows someone to also order an autopsy after a person has died. And finally, it gives authority to an individual to make funeral arrangements. Now, that's a rare event because, as I told you, the power of attorney is designed to expire at death, but under the Indiana statute, this is the only carryover provision that we have in the power of attorney. Hope you found this helpful to know a little more about powers of attorney. Thank you.